we will start this in a few minutes. I want to welcome everybody to this event of the IDC, Instituto de Derecho de la Competencia. That's in Spanish. So the idea of the IDC is to have some discussion regarding competition policy, competition law, and antitrust, and to be part of the discussions we can have. So I will let you with Pablo Trevisan for a few minutes so he can introduce the IDC, and then we will go to our speaker and the event of today.
No, I mean, thanks, Nicolas, and thanks, Tommaso, for joining us at the IDC. The IDC, for all of those who do not know what exactly it is, it's just a place in which we want to promote independent research and investigations on issues related with competition law and policy. It's open to everybody, so we really want to be a place in which all the voices can be heard and be discussed. All the ideas to promote a debate and discussion of ideas on our field. It is not the reason. I mean, the pandemic is not the reason why we don't have a venue. It's something we actually really. It's in the NDA of the IDC in the sense of not having a physical venue because we want to be as independent as we could be. So, said that, Nico, everybody is invited to participate. We are, also important, we do have also an international advisory board in which we have Richard Wish, Ian Forrester, who's also connected, Spencer Waller, who's connected, Simon Holmes, Philip Marson, Magdish Corminos, and some others from around the world. So thanks again for joining us, and the IDC is open to everybody, so please join us anytime.
Thanks, Pablo. Today we have Professor Tommaso Valletti, who is a professor of economics at the Imperial College London and also a professor of economics at the University of Rome. He is currently the head of the Department of Economics and Public Policy at Imperial College Business School. He is a non-executive director to the board of the Financial Conduct Authority in the UK. He was chief competition economist of the European Commission between 2016 and 2019, when he led the economic analysis on many large mergers, as we have Deutsche Börse, London Stock Exchange, Dow, DuPont, Bayer, Monsanto, Microsoft, LinkedIn, Siemens, Alstom, between others. And he also participated on state aid cases and antitrust cases, including Google different cases. So he has a magna cum laude degree in engineering and a flute diploma from Turin, and holds a master in science and PhD in economics from the London School of Economics. So he has published various articles and academic papers. So today he will be addressing some topics regarding concentration trends, big tech, and also we have a recent recent report by the House of Judiciary by the Congress of the United States regarding digital economy, that we can hear his opinion on this. Today, we will change a little the format of the conversation. So if you are, we're willing to have something more interactive. So everybody who has questions, please address those to Pablo or me, or if you want to do it live, please ask for your turn. And we want to have a more interactive discussion. With that, I want to thank Professor Valletti for joining us, and please, Professor Valletti, go ahead.
Muchas gracias, Nicolás. Muchas gracias, Pablo. Estoy muy feliz y honrado de estar aquí con ustedes hoy, pero mi español no es muy bueno. De hecho, es itañol, por lo tanto, hablaré inglés. So I'm going to switch to English now, and I thank for the hospitality by the IDC. So, as Nicolas said, let's make it as interactive as you want. The idea originally was to start from a recent piece which I wrote for the Stigler Center at Chicago University, and I have a couple of slides, which perhaps I can start from that. So it's very much related to the topic of interest today. So what did I do with the Stigler Center? I'm gonna share a couple of slides, really, just a few. So let's see. Yeah, can you see them on the screen? Good. So this is the piece which I wrote for the University of Chicago Stigler Center Pro Market. The title was "Doubt is Their Product." So what does it mean, doubt is their product? So there was a consideration I started. I'm an academic. I should introduce myself. I am an academic who had a policy stint as chief economist at DG Comp, but I'm still an academic. And what's been interesting in the past 4 or 5 years is that there has been a revamped activity among academic economists on very interesting topics, also for people interested in competition policy. And in particular, a few papers got the attention and got published extremely well in academic terms. So you might have heard about them very quickly. This is a paper by Jan de Leuker, Eckhout, and Unger about markups. So they have really a deep dive into plant level data in the US, in Europe, worldwide, and they observe that margins, and margins, it means the ability of a firm to set the price above incremental cost, which is a measure of market power. Margins since the 80s have been skyrocketing high. So they were pretty much constant around 1.3, 1.2, and then from the 80s onward, they went up. This paper is published in the Quarterly Journal of Economics. Margins, topic number 1. Topic number 2, another controversial, well, another paper which has been published in the Journal of Finance. It's about common ownership. I'm sure you had discussion about common ownership in the past. This is the work of Jose Azar, Martin Schmaltz, and the co-authors. And they observe that in US airlines, an index of concentration, a standard index, such as the Herfindahl-Hirschman index of concentration, the HHI, you should be familiar with that, has been pretty constant. However, once you start to take into account the fact that there are some investors which are owning simultaneously different airlines, they may be big passive investors, typically they are the BlackRock, Vanguard, State Street, Fidelity. So these guys, once you take into account that there is a structure of common ownership, you see that common ownership has been growing in US airlines. Obviously in their work they do much more. And what's interesting is that they establish a link between the increase in common ownership and the increase in prices, in the fares, in how much we pay for flying in the US. Okay? And they claim there is a causality link there. So common ownership increased prices in US airlines. This is yet another very famous paper you should have heard one way or another, called Killer Acquisitions. So Killer Acquisition is a paper by Cunningham, Ederer, and Ma. They look at acquisition in the pharmaceutical industry, and they find several things. They found that about 6 to 7% of the acquisitions in the pharmaceutical industry are of the killer type. That is to say, an incumbent pharma company buys another guy who's doing similar research. And then as soon as the other guy is being bought, the research line of this other guy is discontinued. So the acquisition happens to kill. 6% of the acquisition they have, which is a large number if you think about the typical intervention rates among enforcers. Another thing they find is the diagram, is that there is a lot of those acquisitions which go under the radar. As you know, in the US, there is a threshold for a review of a merger. It's called the Hart-Scott-Rodino threshold. And what's interesting is that in this diagram there, if acquisitions are not overlapping, so I'm buying a firm which is doing research over a different molecule, different things, so there is no overlap in our research lines, these acquisitions are random. So around the scope, big, small, below, above the threshold for review. Instead, precisely those acquisitions where there are overlaps, which are those that would be of concern to an enforcer, they are very much strategically concentrated just below the threshold. So you will see there is a 0 on the right-hand side that diagram, and most of them just happen to be just below the thresholds in order not to be vetted. So these are 3 papers, but there is more. So there is a Simcha Barkai, Journal of Finance. This is a guy which is actually looking again at a metric of market power, using completely different approach from Eckhout, De Leuker et al. They were looking at plant level data. This is instead using national accounts. And there are methodologies in macroeconomics, and in finance, in macrofinance, which are well established to see how value created in the economy, how is it allocated to capital, to workers, and to profits. Okay? And this is showing that, again, over the past 30, 40 years, there has been an increase in the share allocated to profits. Okay? This is not capital, this is not labor. The labor share has been going down. Yet another one, Gustavo Grulon with co-authors, a review of finance, starting from, again, mid-80s, an index of concentration in the US economy is on the rise by quite a lot. Okay, so these are several works which have to be published. There are many more coming out on monopsony, on attention markets, on the fact that there have been an interesting relationship that as some big tech markets became more concentrated, venture capital pulls out, okay? Because venture capital doesn't find lots of opportunities for growth. This is a work by Luigi Zingales at Chicago with Rajan and Kamipalle. Other work on privacy and the lack of competition. So these are interesting, and I'm gonna stop sharing these slides. These are lots of interesting results that came out from academics, okay? You may say, okay, that's good. It's somehow related to what I do. But what's been the really interesting thing? And this is my experience as a policymaker. When these things came out, and they've been, it takes time to publish research, all of a sudden I encountered a series of pseudo-academic and pseudo-centers whose job was trying just to rebut the findings. And this was huge. If you go to Brussels, if you go to DC, you don't find academics in the circles that you attend. You don't, okay? So now I am really the exception to the rule in this instance. You find lobbyists, you find advocates. And so there was a surprise in my experience that this research generated a sort of panic among competition lawyers and in the industry. And so what was interesting is that I, for the first time, encountered some places like the Global Antitrust Institute, or I encountered the International Center for Law and Economics in Portland, Oregon, that from an academic's perspective, and this is in front of you somebody who had been working for 25 years in a competition from an academic point of view, in competition economics, I had never seen them, okay? Never seen them. These are guys with no academic credential, so to speak. However, they were ubiquitous. So anytime you would go to a conference in Brussels, or there would be some panel, some debate, they would be everywhere. The few times I went to the US, I went to the Congress, I went to the ABA meetings, I went to these places, they would be everywhere. And they were acting in an interesting way. They were producing pamphlets to be put on a website. They would put and these pamphlets are written well, because these are people who can speak and can write in the proper English, of course. But there is no research whatsoever. And the enforcers are not able to distinguish what is serious research from what's instead, it's an advocacy piece. So BlackRock paid people, the big pharma paid people, the big tech paid people to produce smoke, just to have somebody who would be able to say, yes, there is a killer acquisition paper. However, there is another paper, like as if it is a 1-for-1. And it's not a 1-for-1. These things cannot be considered together. The game of the Global Antitrust Institute and other players like this is obviously not an academic game, and they don't care. They don't care about academic reputation. And again, I will restate, as far as economics is concerned, because I don't know about law. Okay? I'm not a legal scholar, I'm not a legal expert, and will never be. But that's not my job. But I am an economist, and these people have no academic credentials among economists, academic economists, but they are like mushrooms. They go out there and they create careers talking about economics in front of enforcers, judges, and the like. Okay? And they're there as if they are, you know, they portray economics. I would say Mickey Mouse economics is always everything is simplified as if markets are fully competitive. They train people, they train judges, they have access to people on the Supreme Court. I've attended only one event from the Global Antitrust Institute alongside the ABA meetings in Washington, DC. There were 2 judges of the Supreme Court of the United States, 3 senior judges, and at least 7 head of the enforcers, just for a normal lunch that was happening on a normal day. So, but what I really don't like, I mean, they do what they should do, of course, it's the job, but they don't disclose funding, they don't. And they're always, it's a machine, it's a war machine, which is geared to throw smoke on what economics actually is. Economics is not the Mickey Mouse economics that you can get in a 1-week training course that they can give you. Economics is quite a deep subject. Economics has done lots of progresses over the past 40 years, and economists are concerned with market power. However, they go out there, they're always prepared. The main job that they have, so my main job as an academic, I have to teach, I have to do research, I have to do serious research, and then, I mean, in my free time, I'm happy to join your conversation and do something like this, but it's out of my personal will. I'm not paid for that. Instead, these are people who are paid 100% of their time to be ready anytime there is a hearing, anytime there is a case, anytime there is something with no disclosure. And that's a minimum requirement you should always ask when people talk to you. Ask for disclosure. That's really the bare minimum. And here I disclose, I have nothing to disclose apart from being a non-executive director of the Financial Conduct Authority, which is the regulator, the financial regulator in the UK. So you should always ask for disclosure in this business because there's just too much money at stake. There's just too much money at stake. And this is competition law, finance perhaps, and perhaps some other, I don't know, but competition law has been the business I've been the closest to in the recent times. And so that's the business I know a bit more. The economist, so one point you should always be aware of is that what some of these think tanks, lobbyist groups, research centers do is not clean. It's not clean at all, and it's not what economics is about. They're going to tell us repeatedly that mergers are efficient. There is no presumption in economics that a merger is efficient anywhere. Actually, there is a presumption in economics that mergers of firms which are competitors are anti-competitive. This is a presumption. There is a structural presumption in economics which has been lost. And I don't understand why people have lost this presumption because of the work and that which has been done by these move operators and their consultants. Because consultants also are a strange breed, I should say. Okay. I don't know if there are consultants among you. It's a job like anyone else. But people have to do a little bit of soul searching about using one's time, one's intelligence in order to come to answers which are fair answers when there are real problems. And I do believe personally, with the research I've done and the cases I've seen, that we have a gigantic problem with market power because of a lack of enforcers. So you have to take with a big pinch of salt what these people say. As another example, but it's an indicative example, just because I got more close to policy circles in competition law. At some stage, I read a submission that Jeff Money of the Oregon Center did in front of the FTC, arguing that there is a presumption in economics that vertical mergers are efficient. Okay? There's a presumption from the economics literature. And again, you have a guy who's not an economist, who doesn't have any credentials to be an economist, who tells the truth to people, to enforcers who listen to him because he's there. Instead, the real academics, they're doing something else. They don't have access to those places. And since I saw it, and there is no such thing in the economics literature when it comes to firms with market power, when it comes to firms with market power, there is a trade-off. You may actually reduce the double marginalization under some condition on the contractual forms, but because of market power, you can also increase the incentive to foreclose a rival. So it is an empirical question, but there is not a presumption. However, in the little piece, the pamphlet, the brochure, the glossy thing that they had prepared for the Federal Trade Commission, they did their own selected analysis of the literature, including a very nice paper from a great colleague, Greg Crawford et al., saying, as shown in their American Economic Review paper by Crawford et al., they said, look, but that paper, you haven't even read it because it doesn't say that. And they said, look, there is a phrase and there is extrapolation of a single phrase. I had to force Greg Crawford to get a Twitter account in order to state publicly that in his paper, they never said that there is a presumption of efficiency from a vertical merger. But I had just to shake him up because it was one of those great but sleepy academics to shake him up, to take stance, to take a position, because otherwise the result of academics was even misinterpreted. So I had this experience that was really interesting, and this became one of my many fights that I currently have of doing two things, of exposing, because I don't know how to stop the smooth operators. So there is a disproportion in the resources that we have, because I'm alone with a few others, and I don't receive fundings for that, and instead they are constantly funded and disclosed. But one thing is be aware. Second thing is expose. Third thing, at least ask for the bare minimum for a disclosure of the real money, where it comes from. If you're interested, the New York Times did an investigation, and I was very happy to help them, on the workings of the Global Antitrust Institute. And it's not just this throwing smoke on what economics is and what economics has done in the past 40 years, but it's a network. It's a network of training, and I would say, if I may, brainwashing judges on the simplistic view of economics, which is not what an academic economist. I don't study for 25 years industrial organization because everything works fine. I studied this because there are problems to solve. Otherwise, I would not have devoted a career to those studies. And so they train judges, they have access to the judges, they tell them everybody's fine, and they're constantly there. So I think it's dangerous. I don't know how to solve it, but this is an example where I would like to, at least to give you a little warning. So these were some of the consideration, and the consideration then move on more to the academics, how to get the academics engaged, but it's less interesting for a audience like the one we have today, which is by and large not an academic audience. So this was the topic of the piece I did for the Stigler Center. And if you're interested on the specificities of those studies which I mentioned, the increasing margins, the increase in the share of profit, of common ownership or killer acquisition, feel free to put any question you want in the chat. And these are topics that we can cover. So as you start thinking about your questions, I may touch upon the other thing that Nicolas mentioned in the introduction. We are reacting today to what the US Congress published the other day. It's a long document, 450 pages. I don't know if you managed to read. I read the bits and pieces. Something I was more familiar with, also because I went myself to give, I was called as an expert witness in front of the US Congress on the problem of competition and privacy. So what do I think about the document? The document is great. The document is Obviously, it's a political statement, which you should expect from politicians, and there's nothing wrong with that. But there is also a lot of background research that you can start criticizing bits and pieces, but it's a big picture that matters. And the big pictures is the big picture that to me matters, and it matters also in Europe, is that there is a recognition by some people, I certainly belong to some to this camp, that we failed to see a massive problem coming. We failed. We can discuss about the origin of this failure, but we failed. So we have created an accumulation of market power in the hands of basically 4 firms, which is unprecedented. These 4 firms, I am excluding Microsoft, these 4 firms are worth more than $5 trillion. These are figures which are difficult to understand. And these 4 firms control large access to our lives. So the way we communicate, the way we have our relationships, the way we buy, what we browse, what we write in our emails, the videos we watch. I mean, you name it, you name it. So they have some control. And this is an economic control, and obviously there is a political problem with that. So one cannot just avoid looking into it. The accumulation of market power has emerged for several reasons. Many of them are benign. These companies were the early innovators, not always the first, but definitely they're made by great computer scientists and great engineers. And this is good, and nobody is ever questioning that. But at the same time, this extreme growth has also happened because we allow them to grow, not enforcing our existing tools. So the biggest one, the obvious one, has been a total under enforcement on the merger side. So the Congress mentions, people say 500, but it's actually 550, which are documented by them, plus about 250 by Microsoft. So in the last 20 years, there have been in the excess of 800 mergers. By the way, the stats of the US Congress stopped a while ago, and instead these mergers keep going on. So we're talking about in excess of 800 mergers in the past 20 years that have been approved. Not only that, but they've been approved, there has been zero prohibition, and by any standard, 0 cannot be the right number, especially when you have so many. But even more worrying is that 97% of them globally, this is not just in the US, globally have never been vetted by anyone. And why? Maybe political reason. We didn't want to break Silicon Valley when it was coming out. That was done by Obama. It's been continued by Donald Trump. So the reasons go back in time, but the reason is also that enforcers are not very good at looking at how dynamic in the industries evolve. They're very shy. They are very insecure, as we said many times. They look at precedents. We have created this, we have created really a negative loop where the lack of precedents means that enforcers are not doing anything, which means that then there is even no precedent and they keep doing nothing. So nobody can really break this, this bad machine, this bad equilibrium that we have created. An example, a key example, which is happening right now in front of our eyes is Google Fitbit. Google Fitbit, that, I don't know, the Department of Justice, but from all the rumors I hear in Europe, despite a phase 2, it's going to be cleared, okay, with a remedy which is not a serious remedy. Why is it going to be cleared? Because the commission, commission is made of civil servants that want to live a quiet life. They want to be, of course, principled on the precedents, but they don't really know how to analyze industries. They know how to do cement, yes. They know how to do static effects between beer. They can do something like this, but they don't know how to do data companies. But when it comes to data companies, the Commission has already completely bought into the proposition, which is, of course, a selling point of Google, which has been regurgitated by the Commission, that this deal is about devices, it's not about data. So if you start from that premise that it's not about data, you're missing completely the point. You have Google, which is a data company, which can cross-link in unprecedented ways all what I said earlier, what we watch on YouTube, what we write on Gmail, the ads which are served to us, the browsing session we have, everything, okay? And they can create these profiles. So it's a data company that then monetizes through ads. And you cannot be concerned that this is, again, another deal about data. Okay? You can't. If you say it's about device, you're just given up to start with. So enforcers are not going to go, they don't want to, and this is interesting. There's many of you, of course, in the audience which are lawyers, and I never understood why a DG Comp in particular, maybe among other enforcers, is different. There is this timidity, this great fear of losing in courts. Okay? This is like, I never understood if it is a real fear or it is just a justification for doing nothing. Okay? So this is, I never actually understood that. But there's a fear of losing in court, and therefore, if we try to block Fitbit, then we're going to lose it in court. Who cares? Guys, who cares if you're going to lose in court 3 years from now? Because this is a deal, again, and it's not about you know, conspiracy theories. Let's try to do what an assessment should be doing in a merger. Any merger is about trying to predict the future, okay? So it's not so that we adopt, we have to predict the future with and without the merger. Okay? And we have to understand what might be the consumer harm with and without the merger. Now, I tell you the following proposition. Do we really think that if we block the merger, okay, we block the merger, do you really think that the world will be so much worse? Do you really think that Google doesn't have the ability to invest? They are claiming they want a piece of software that can become, can make them a little more efficient. Do you really think that perhaps making a mistake, and the mistake is that Google will not be able to purchase something that they can do in-house, because this is the counterfactual. And this is a company which has mighty power. They can, in a single day, I don't know, fix the debt of a country like Greece in a single day. Okay, this is the power that they have. Do you think that they cannot do the research themselves? Of course they can. Of course they can. And instead, if we allow the merger and it goes wrong, what's going to happen? It's going to happen that without us understanding very well, it will be able to get also our health data, our emotional data, 24 hours a day. It will be able to do the same they did with Android. Wearable watches can become an operating system, and the incentives now to allow other, so if the next Android is a wearable operating system, they can do the same trick they already did in the past. So these are companies which have a history of having done antitrust abuses. And again, if I have, as a citizen with an interest in policy, and I want to put myself into these two worlds. In world one, I don't allow Google to purchase Fitbit. Okay? What happens in that world? Okay? Either nothing, okay? Or, and that is the hope of somebody who believes in a competition, someone else may actually get Fitbit, and there is more competition. Finally, there is another search engine that can emerge, and there is competition on the merit, which is what we want. As opposed to the alternative way, I do allow Fitbit to be bought by Google, and things can go really horribly wrong. This is a company which has already tremendous market power, so don't think that there are benefits out there. What is the benefit if you already are and I can tell you the possibilities. They can do even more hyper-targeted advertising. Of course, they're saying words. We will never use your personal information for targeted ads, and we will not do this for 10 years. A, do you believe the words? B, there's a fundamental mistake there, because obviously Google doesn't need the information about Tommaso Valletti. Okay? They don't need my personal information. They just need some information of somebody which has some statistical characteristics which are similar to me. So statistical characteristics, they can cross-link, they create signals. And so even if nominally the letter of GDPR is actually fulfilled, what we will do is indeed they will use this information to create even better statistical profiles. Better statistical profile, is this efficiency? No, better statistical profiles is efficiency when you have a level playing field. Okay? If you have lots of firms, forget about privacy interference now, if you have lots of firms which have lots of information, you can really have thriving competition market by market, and that's great for consumers. But the worst case, if you remember from textbook economics, for consumers is what we call first-degree price discrimination. So there is only one firm which has that information, and then this firm will use that in order to extract all the consumer surplus from each individual. Okay, that's the worst, okay? And this is not really a case which I'm just making it up. So we are allowing Google to get to a situation where they can become, they already are perhaps, but they can even improve even more this situation as the perfectly discriminating monopolist, which is the worst for consumers. Plus, you know, the advantage they can have in insurance. Let me give you this example from financial markets. So in financial markets, we have some rules which don't allow to discriminate people according to certain characteristics. We cannot. For instance, we cannot discriminate a loan on the basis of whether a person is undergoing a divorce proceeding. However, divorce proceedings are one of the main reasons for people getting in financial distress, as you might imagine. Things goes wrong, it's very costly, you have to give money to your husband, ex-husband, your wife, ex-wife, something like this. So it's a very, very important variable there for understanding whether somebody is going to repay you back or not. Imagine Google, with the information they have, entering this financial market. Google, because they probably know even before we do, because they know your searching behavior, what this information you were looking for, your emails, whether you were going on a dating site or not, knows extremely well, a very strong signal about whether your relationship is going well or not. Okay? They know extremely well whether you're going to break up, whether you are likely, this is just, as I said, they want a signal. You're likely to be going through a divorce proceeding or not. So they will have information, which is information extremely valuable that no one else has. And what does this mean? This means that they will be skimming the market. They will never offer a particular loan product to this person, and then therefore, the other players will just be left with the lemons. And this is, again, one of this unleveling the playing field that we have to consider. These are considerations, to me, which are so big and so great, given where we are in 2020. And these are not theoretical possibilities. These are where we have been already for a few years. There is enough evidence about that. But, however, I see that the enforcers are very reluctant to go. Very reluctant to go because of lack of precedence, because we don't have the data, because they never release data for independent assessment. So, going back to the US report, they make some of these points, but then they're also saying, severe under enforcement, it's a real problem. Let's change the law. Okay? Let's change the law. And the law, and they propose several things. Some are very dear to me. The most important one is something that perhaps will be anathema to some of you, but for me is really the way to go, which is the reversal of the burden of proof. The reversal of burden of proof means let's stop having this discussion about market definition, the silliness of market definition. This is where economics has lost big time or has contributed to throwing smoke on this. Most of the cases I saw as chief economist, and I am an economist, of course, was on this very narrow perspective. Let's try to measure with prices. And this is also where academics produce lots of damage, in my view, missing completely the big picture. And again, if Google Fitbit becomes a discussion about devices, okay, devices for sport, and sport devices or something like this is really missing the big picture. And we've seen it in many other cases. In beer, we allowed ABF Miller to create a global monopoly, and we did a standard analysis. Let's look at the brands. Is Peroni competing against this or that? Let's have a narrow approach. Let's do the divestiture of these bits and pieces, not knowing how the business operates, just to observe a few years later that the price of beer went up. Okay, so we really used economics as a straitjacket, and instead economics is much more interesting. Of course, you have to conjecture, you have to use theory, you have to have some thinking about it. But economics, the way we use in competition policy, is a straitjacket. So reversing the burden of proof would throw away, not in general, but for the super dominant firms, because these are the object of my considerations, throw away all these unnecessary discussions we have in every case where you have also a very asymmetric playing field, because the Google can throw 70,000 consultants, and DG Comp currently, I know that, for instance, among my former colleagues at the CET, the Chief Economist team, they have 2 people on the case. And therefore, these are the resources that you're talking about. If we get rid of that, we would be asking basically, Google, you are a super dominant firm. I don't see why you really need to purchase Fitbit. Why? Why do you need that? Okay, you have to prove to me in a cogent way that consumers will actually benefit from that. So it has good economic reasons, good practical reasons, because the resources of the enforcers are limited. And if instead DG Comp now, I think it should, but if it tried to do a battle, they lose in court, people are going to be burnt. They're not going to do it again. Okay, they're not going to do it again. So let's get rid of that. Let's get to the substance of the case, and let's Google do the job. Let's Google actually have to prove in a cogent way that the merger is necessary to achieve a certain objective. So if Google wants to enter insurance market, fine. I'm not saying we should have restriction on line of business. But Google or Amazon or Facebook, they need really to prove to the authorities with real data, with real business plans, that in the counterfactual without the merger, they couldn't do it by themselves, which I find it, to me, it would be the right level of proof they have to bring, which is very high. And then otherwise the merger would be blocked. As I said, society will not be worse off if Google cannot buy yet another firm. I don't believe so. I don't think there are these super efficiencies. And again, this has been an obsession of economists on efficiencies, but where, by the way, we don't have evidence from the data that mergers generate efficiencies. Please show me where that evidence is, if it is not cherry-picked, of course. And even if it is an efficiency, I really want to see the impact on consumers. Otherwise, I will block it. So reversing the burden of proof, in my opinion, is the way to go. And I hope there is somebody out there among the legal scholars, because I don't know what it takes to change a law, and maybe it's extremely difficult. I believe it should be, but it would be great if people started pushing in that direction too, because this is the right moment to do it. Then there is also the other discussion, but perhaps we are expanding too much, that of course is not just about competition policy, there is also regulation. And the regulation is as important, but it's not an either or. We can do both. I don't see why we have to select one of the two. We should be doing both. When a company becomes a bottleneck or whatever, an essential platform, call it the way you want, we have experienced in the past situation like this, and we tried to make sure that through some levels of regulation, we could still have competition. So we did that in electricity, we did that in telecommunication, we did that in many other sectors. And the principles are correct, of course. Data is not telecoms, it's not electricity, there is going to be differences, but the principles are not that different in my view. So what's quite notable in my perspective, because prior to doing some competition work, I did some work in regulation of telecoms in particular. And if you asked any person in the telecoms business, on the side of the operator, on the side of the regulators, it doesn't matter. And if you ask, I am based in the UK, British Telecom is a fully integrated operator. Can they offer a different price to a competitor for the local loop compared to what they impute themselves for the local loop, for instance? Can they do price discrimination over access, over wholesale prices? And people say, no, they cannot, because this is something that cannot happen, because we want to have a level playing field. So the lack of discrimination, which is a principle which is embedded in all these industries, which have network effects, which have incumbency advantages, and so forth, are so ingrained that people don't even have to ask. Instead, when it comes to self-preferencing in the Google case, or perhaps in the Amazon case, or whatever, people start having, I don't know, they almost die when they hear about that. When we ran the Google shopping case, we were mocked and ridiculed for having a concept called self-preferencing, which from an economics point of view, once again, is a very standard economics. There is nothing. But my point, and let's see now if there are some reaction from you guys in the audience, is that economics has been extremely conservative in the application to competition law. Economics is not what is being portrayed by the consultants or by the advocates. It's not. So if you go to the, what economics has done in the past 40 years since game theory or the empirical revolution has found many more nuanced results, to say the least, okay? And that's why it's been an exciting field, because there is a lot of problems to fix. This message hasn't percolated to competition enforcers for different reasons. The disengagement of academics, the smooth operators, or the guy or whatever, or whoever they are, for whatever reasons, these economics has not gone there. I'm doing my little bit to tell you economics is slightly different, but still we have to move on. As an economist, and I think I'm a very orthodox economist. I publish my papers subject to principles and all that, but I have started appreciating when I saw the way economics was being used as a tool to bring doubt into everything we do. And doubt basically means just sticking to the status quo, and the status quo is a reflection of power. So power is there and is never going to be moderated. So when economics is used like that, I have become very much sympathetic to legal arguments of reintroducing presumptions in antitrust. Presumption that we had in the 60s and the 70s maybe are being told. I wasn't even born in the 60s, but I was told that these presumptions were extreme. But now the only thing which has remained as a presumption in economics is that a merger to monopoly is bad. That's the only presumption we have, and that's ridiculous. So let's go back to some presumptions, because there is a pragmatic problem of resources. Enforcers don't have infinite resources. They cannot devote all the attention they should on every case. And the presumptions, in some limited cases, super dominant. You want to have a market share of 70%, fine. Let's have lots of people discussing whether 7% or 65 or 75, but that's not the point. So it's when you have a series of parameters all pointing in the same direction, let's reintroduce these presumptions. So then we can concentrate our real attention and efforts on those cases which are gray areas. There are gray areas of 4 to 3 mergers in telecoms, for instance. I'm personally against, but there may be discussions that we can have. So we can focus our energies on those cases. And instead, these super big firms, if they want to grow organically, let be it. Let's do that. But why should they grow by swallowing up yet another potential competitor? I don't see any reason whatsoever from a social welfare perspective. The added advantage of this is also in a situation where we prevent market power from emerging. Antitrust enforcement also is going to be easier. So now we are wait and see until we see there is a problem exposed, but in this dynamic market is extremely late, etc., etc. Instead, if we prevent the super dominance to arise from mergers, we also have a very positive spillover on less abuse of dominance later on. But I'm going to stop here now, and I would be very happy to take questions from whoever wants to break the ice.
Wow. Thanks, Tommaso, for such a provocative intervention. Honestly, I think there's much we might discuss. I have a lot of comments, but before getting the monopoly on the voice, I would give the floor to Simon Holtz, who I think he sent a question on burden of proof on mergers. Simon, do you want to do it yourself?
Thanks, Pablo, and Tommaso, great talk. And as you probably know, I share your concerns about the misuse of economics in some of the areas I've been working on, climate change, sustainability, and competition law. But don't worry, I'm not asking about that. You referred to the absence of a presumption that mergers are pro-competitive and that there's not evidence that mergers are efficiency enhancing. And yet we do have a situation, as I think you clearly acknowledged, where in Europe and in many countries, essentially the authorities are neutral. They have to prove either way that a merger is bad or it's good on a balance of probabilities. And in fact, in the States, although I'm not a US lawyer, I think it's essentially the other way around. The authorities have to actively prove that a merger is bad. So I was going to ask you whether you thought there was an economic case for reversing the burden of proof. Now, clearly, you went on to, after I put my question to Pablo, you went on to say that there is. But are you speaking across the board, or are you talking, as some people have, that there is a case for reversing the burden of proof above a certain threshold in the context of certain big mergers, above certain market shares, or some way of demonstrating market power? Or are you talking about across the board? Because the logic of what you've said, I think, seems to suggest to me that the burden ought to be on the authorities to prove that a merger was bad. I'm not actively advocating that, it's a genuine open question.
So if you take any standard economic model of products which are horizontally differentiated, so forget about complements, forget about this. So when there are overlaps among firms, any model of a merger will tell you that prices will increase in the absence of efficiencies, any model. So there is a general presumption from economics that a merger is actually bad, and this presumption has been lost, okay, has been lost. In practice though, what economics will also show you is that the impact in the absence of efficiencies is really marginal if you have many firms there in the market, so 10, 9, 8. As you start having more concentrated markets, instead, these effects are pretty bad. Or put it differently, if there are some efficiencies, which may exist, it takes a small efficiency in a rather unconcentrated industry to make consumers at least as well off, but at least not worse off. And instead, the efficiencies that would need to come along are extremely high in a concentrated market. To put numbers, although regulators will say we never do that, but I've seen the practice of things. There are rule of thumbs which are followed by enforcers precisely because they have to handle hundreds of cases. At the Commission, we had 500 cases every year, something like this, so large numbers. And there are rule of thumbs where basically a 6-5 merger, let it go through. A 5-4, let it go through. A 4-3, this was the threshold when for many years the enforcers start getting really anxious about. Really anxious about. And now, if you take the results we know from these increasing margins, this is the Eckhout. Look at the first slide I actually pointed out. Imagine you had a welfare concern in a standard 4-3 symmetric merger. Imagine we think that on balance, of the evidence we have, sure, there are differences by industry. We have a 4-3. This is when we start getting anxious about the impact of the merger. Given the way margins have increased in recent years, if you had that concern 4-3 20 years ago, you should have exactly the same concern for a 5-4 merger now. But not because you've changed the standard, but just because the damages that can arise from consumer in a world of high margins are actually so much worse compared to a world of low margin. So all this is telling us something, okay? So adopt, so your thresholds have to change, not because you have changed the standard. How to put this in practice? I'm very happy to have, you know, some thresholds below in a very unconcentrated industries. Let it go, let it go. We are not concerned about unconcentrated industries. We are not concerned of those. Okay, so I will not have any presumption for if the concentration of the top 5 firms is below 4% or something like this, for 40% or something like that. I wouldn't have any concern in those industries. Instead, so I'm happy to have some safe havens for unconcentrated industries and not spend any resources there. And I will have instead some strong presumption when it comes to super dominant firms which have in excess of 60, 70% market share, 50%, especially if this has been going on for long periods with high profits, and so there is no dynamics there. I would be very much in line of introducing. So that's the answer to your question. It's not, although economics would tell me there is a general presumption, but there are also efficiencies which I do want to take into account that might exist. The burden of proof, we can discuss who should bring those, but I would say for small firms, no presumption whatsoever, let it be lenient, they can go. In between, we can discuss, and then there is a clear threshold for dominant firms, and that would be my concern with the Google, the Facebook, and the Amazon, where they have to do the dirty work and explain the authorities why they want to merge.
You're going to need a lot of economics to decide whether or not you've got that concentrated market and how many players you've got in the market before you know what the presumption is. So yeah, and I understand entirely the theory, but it's going to be...
Yeah, but Simon, if we want to move the bar, we cannot always try to think about, okay, the difficulties of implementation. We have to start devoting resources.
I'm not disagreeing with you.
The practicalities of this, on how to change the system. And then every change is going to be imperfect. It doesn't seem to me that the current system has worked particularly well when it comes, if 900 mergers, 800 plus mergers, 97% go unvetted and 0 have ever been blocked, the current system for 20 years. It's long enough to say, let's try, maybe not to do the opposite move, to swing the pendulum to the opposite, but at least some more than incremental, a sizable change compared to the current system is needed.
Yeah, understood. Thank you.
5 to 4 sounds like a lot here in South America and Latin America. I don't know how many markets we have with 5 firms, but saying that, I want to give the microphone to Juan David Gutierrez from Colombia. Juancho, go ahead.
Colombia, te quiero muchísimo.
Indeed. Bienvenido, Tommaso. Thank you very much for the presentation. It was very interesting, and I liked your piece as well. In your piece, you mentioned that you don't know how to fix a problem, but you provide certain advice for academics. And I have a couple of reactions from the point of view of Latin America, because we're in a Latin American venue, after all. And in Latin America, very few academics, both in economics and law, actually work on antitrust and international and industrial organization. There's simply not many spaces for them. Many lawyers who are interested in the topic may teach part-time, but I don't know more than 2 or 3 lawyers who teach and research on antitrust in Latin America. Maybe there's more economists, but perhaps a handful of them. So we don't have much independent research going on in Latin America from the point of view of academia. So you can imagine that wherever we are, we're probably worse then, because we don't even have much academic production, first. And second, interest groups will always be there in any important topic, and we will always have companies pairing with think tanks of diverse sorts to put forward their arguments in many ways and through many stakeholder clans. And decision makers always need someone who processes whatever the academia or wherever raw information is out there. And I guess this is how think tanks and other type of organizations would try to process information and give it in a a smaller size to eat for the decision maker works. And perhaps there's many of these type of think tanks with certain ideology or certain interests, and very few with other ideologies or other interests that balance it. I mean, if you ask me, then I know very few organizations that embrace, for example, ideas that oppose those of certain of the organizations that you cite in the paper, such as, let's say, the competition, the Inclusive Competition Forum from Michel Meagher. But I don't know many, there's many organizations like that, that you could do also the countering. So the bottom line that I'm saying is that, okay, I find that academics should engage more with policymakers and try to provide their insights in a way that's more palatable for decision makers. But what about if we also just need organizations that also are able to process and produce information and training sessions to judges, perhaps in a more transparent way and not with the same unfortunate means that other organizations that you mentioned in your paper produce. So I'm sorry for my long intervention.
Well, I think we are in large agreement, but you have to think that a few things have been moving in the recent years. So there is I think, more awakening now compared to earlier. You've always have to think about in the incentives of various actors. So unfortunately in academia, and that's why you don't see lots of research, lots of people there, is that the incentives of a young academic is to publish, to get tenure. In my field of industrial organization, we became very narrow in following a certain type of empirical work. If you cannot measure something using structural demand estimation, which is done in a certain way, you don't really publish well. If you don't publish well, so the average work in industrial organization takes about 5 years to be done and be published. So the times are not really consistent with the times of policy. So there's a problem in academia, and the solution there is that people in senior position like me should try to say, let's give also the chance to papers which are interesting, to ideas. So this is it's a general discussion which is happening in economics. So do we want to be very precise on something which is irrelevant, or do we want to promote circulation? So people, economists believe that we are really social scientists. We should only do things which we can prove. I don't think that this is ever going to be possible. So I am more much in favor of promoting debate about ideas, even if the empirical evidence is not there because data sets have never been made publicly available by Google, Apple, Amazon, and the like. So there is a discussion among academics. The policymakers, we have to be careful. This is the way we set our institutions. The difference I found between the US and Europe, people working in for the enforcement agencies are very well motivated, but they are civil servants. They want to have lives with families. They work, sometimes there are intense bursts of activities, but on average, they don't work as intensively as in the private sector, for instance. The difference between Europe and the US was really in the system of revolving doors when it comes to the front office. So the big guys in power at the DOJ, sooner or later, they go back and work for a big law firm, okay? All of them, with no exception. And now they may also go and work for the Google, etc. This doesn't happen in Europe, for instance, okay? Maybe people are less good, I don't know, but there is less revolving doors. So it's very rare that a director of DG Comp goes and work in the public sector. They have a career at DG Comp and they stay at DG Comp or maybe in other parts of the commission. So revolving doors are very important. Disclosure. Too many of the enforcers are invited at events that you don't know who's paying for them. So these are, again, minimum requirements. But if you start adding up, you can start creating a momentum. But you have to acknowledge that the battle is always going to be an uphill battle because if you have in front of you, it's not just also Bayer Monsanto, the merger was more than $100 billion. The interests at stake were so big that no matter how much we could do on the innovation theory of harm, we were actually 3 guys working on it. So it was great, it was exciting, but then, and we could pat our shoulders, but in the end, the resources, so if somebody's interested in increasing resources, this is also being discussed at the level of increasing resources to enforcers. That's also something that's, it seems to me that the public return to investing in a better enforcement is so high that we should give more resources rather than less. And international coordination, you said Colombia and other Latin American countries, you are even smaller, so you don't have even less resources. We are in a very unfortunate historical moment where multilateralism has been lost for various reasons, but when you have all the problems that we mentioned until now are quite global. They're not related to Italy, France, Spain, or Colombia, or Ecuador. So this is where the enforcers need to talk to each other a lot. So the ICN is a great forum, and it's working fine. And I would promote more of that. But it's important that new ideas circulate at that level, and they're not always preempted, because some of this discussion has been preempted. And enforcer, it's not their job, but they need to be trained how to distinguish between somebody who published in Econometrica, in the American Economic Review, and somebody who responded with a pamphlet, which is going nowhere other than the website of whatever institute, and then it stays there. But if enforcers, maybe just, there should be somebody filtering this information. Another case in point we had recently was a conference where the killer acquisition paper was presented. This guy, Jeff Money, and others had their own interpretation of the facts, saying you're not showing that this was anti-competitive because actually companies acquiring this company were just learning about the probability of success, etc., etc. So they were telling just another story for the benefit of those who wanted to hear. The big pharma really wanted desperately to hear an alternative story, but it took, once again, Florian Ederer to say, but I mean, this is bollocks. This has nothing to do with what you can say from the paper. This is completely wrong. And by the way, if you think you're right, feel free to submit your discussion and your alternative interpretation to the Journal of Political Economy where we have published. And then you can, if you can actually pass this threshold, by all means, we can have another conversation. But obviously, these guys they're not able to submit there because. I would repeat, most of the time they don't know economics, okay? And certainly they don't know statistical analysis, but they know a simplistic economics that they keep repeating obsessively, and that's not what economics is about.
Thank you, Tommaso. I'm sort of concerned with the timing, but we have like 5 questions, at least on my end. I don't know if at your end, Nicolas, but let me give the floor to Judge Ian Forrest. He had a question on appeals at the commission. I think it's interesting to listen to his comment, the question, and your answer.
Okay. This is a demonstration of the flexibility of humans in the face of the pandemic to use technology in a creative manner. And those of us with gray hair are kind of surprised that these things are possible. I have a point where I want to agree and a point where I want to be skeptical. It is true, and I agree with you, that the European Commission is extremely nervous, timid, cautious, anxious about the possibility of losing an appeal. And I think that anxiety is excessive. I think that we would have a healthier, richer jurisprudence and guidance for the world if there were more appeals and if the Commission were to lose a few more times, perhaps by being overbold. I think that would be a healthy thing. I think an administration that wins 95% of its cases, that's, I don't know what the figure is not maybe being vigorous enough. On the other hand, and here I slightly disagree, in the case of a merger, a negative decision by the institution means the merger stops, and most likely it will not happen. Out of our court, my former court, will take something like 2.5 years. Now, the availability of judicial review is absolutely essential in order to achieve a democratic, accountable, non-arbitrary system. So we're in the strange world that, although in theory an appeal is available, once the institution condemns it, it's not going to happen. And there's no effective judicial remedy against that. And so the slowness of our appellate system is valid, particularly for mergers, but also for huge antitrust cases where Google shopping, whatever the cases may be, the decisions of the Commission are hundreds and hundreds of pages long. They are repositories for many, many, I won't say irrelevant, but peripheral accusations. And the pleadings can be easily, it may well be 1,000 pages or 2,000 pages with a pile of annexes. Now, that is desperately slow, and so slow that the court not delivering to the justiciable an adequate level of service. And so I would be glad to see the emergence of either in-house in Brussels appellate instance, or maybe, but I don't see how we can do it in merger cases, maybe in antitrust cases, the greater use of interim measures. In interim measures, you're not, the institution isn't saying, we're absolutely right. We're boldly saying, these are the basic principles. Shortly. Now, that kind of case could come to Luxembourg and could get an answer within a reasonably short time. And last comment, apologies for going on so long. Your approach assumes that there are no losses from a condemnation. And I'm reminded of the precautionary principle. The precautionary principle, if abused, gives ministers and officials justification which may not be rooted in science, or may be rooted in one scientist or half the field, to condemn something which might be useful, which might be healthy, which might be fun, which might add to the store of human happiness. And the precautionary principle is a kind of cloak to justify controversial prohibitions. And if we go as far as you're suggesting, I would be afraid that recalibrating the burden of proof might be a little bit like the dangers of the precautionary principle. Sorry to go on so long.
Well, it's always a pleasure to hear you, Judge Forrester. It's so we are also in agreement in some areas and in disagreement in others. So antitrust proceedings takes too long. I don't know how to reform that. It would be great to put a timeline. You also know that companies now take all the, the tactics to delay cases, not to provide information, etc. So if you can fix that, you can put also, like we do in mergers. Mergers, they must be assessed within a certain number of days, and we should do that for antitrust too, though there will be other problems. Where I disagree, or at least I don't know if I'm fully clear, is that when we are in super concentrated markets, okay, the damage, so it's really, there is the damage that can arise from further enhancing the market power is great, okay? So there is a loss function which is asymmetric. To put you an example, as any analogy is as imperfect as it may be, we do impose regulation on a lot of stuff in our lives, okay? but the regulation that we impose is proportional to the damages that we are trying to fix. Put it this way, if I am trying to introduce safety measures for a nuclear plant, okay, I will never be content by saying it has to be more likely than not that the plant will not explode. Okay? Because the damage that can arise from the, so I will want to be absolutely bloody sure that it will not happen. And this is what we have to think when we are imposing this change in the attitude. And this is missed. And this is missed in the current environment. I also want to remind ourselves that we need to see how the system has worked. We have to also do some soul searching how the system has worked. We've done not enough, but all the exposed assessments of the mergers which have been done, they systematically point to increases in prices. Okay? We never see how, I don't know, the trustee is actually implementing the remedies. We never know how about the remedies work. So we have created also a fictitious thing of our merger enforcement as if everything works fine. It doesn't. And we cannot just avoid looking. I'm an economist, I'm not a legal scholar, and I cannot think about these global categories, but I can see that what we have established until now, to me, it's a broken machine that has to be fixed. The best way, again, there are people much better than me. I can also point to the problems there, as that's my current job. And I have some solutions. If people can come up with better solutions, I will be the first one to be happy.
So we have the last question from Jessica Medina. Jessica, if you're there, please, can you address the question?
Yes, thank you for giving me the word. I would like to hear the professor's opinion about the incentives that, or actually, what could be the incentives for innovation for a startup? Because that's one of the claims of the academics. They said that if we don't allow big techs to buy these startup companies, then it will be a decrease in the incentives for the startup companies to innovate and to start businesses in the first place. And second of all, I would also like to know the geopolitical aspect of this, because most of the companies are in America, and then it is that they have the power to control the data they have around the world. So, for example, something that someone said about the Colombian and the Latin American aspect is that we are controlled, or we are dependent on the competition authorities that make decisions about the mergers in the companies that operate around the world, but they don't have, for example, a basis in some countries where they are supposed to have an impact or an indirect impact, and we don't have a say, we don't have a word in this assessment. But so we have to rely on the competition authorities or foreign competition authorities in that they make the best decisions for the world. Thank you.
So thank you, Jessica. On the first part of innovation, you have to think a bit more. You have to think a bit more because first, so the argument is that there is lots of startups and they are innovating for exit. So they just want to be bought. That's why they innovate, because they want to be bought. Okay? So the first reaction to that is that if I don't allow Google to buy Fitbit, I would allow instead Fitbit to be bought by someone else. Okay, so it's not that I'm blocking any acquisition. I'm simply blocking the acquisition by the super dominant company. First thing. Second thing is that you are taking for granted that there is any empirical validation that they wouldn't innovate. That's again wrong. One of the work which I didn't expand on, but I alluded to, it's Rajan Zingales and Kamepale, University of Chicago. They look at precisely this question, and they look at in those sectors, they concentrate on the acquisition by Facebook and by Google. In those sectors, when the market became monopolized, respectively, by Facebook and by Google, they look at venture capitalists, how they were, financing the startups in those sectors. And And they show quite nicely how actually it's the opposite. Okay? The empirical evidence, despite what you are being told by some well-informed person, and it's the opposite. That venture capital exits, or at least reduces the rate of funding once an industry becomes monopolized. Okay, so even from that perspective. And third aspect to think about, and more generally, since here we are just elaborating in general terms, you have to think about the direction of innovation. So if you want to invest to become rich, that's fine, okay? But you are investing just in order to be swallowed. Forget about Google. In pharmaceutical, if you're just doing something which is a copycat of an existing thing because you just want to be bought in order to preserve monopoly rents, that's not a good innovation overall, okay? So innovation is when innovation is ambitious, is disruptive, or is incremental, is doing something more. So in a world where the Google cannot buy you, maybe you divert your attention on something which is more drastic or a different research trajectory. So that it would be great to talk to the entrepreneurs. In this discussion, tonight you have me, and I appreciate, but most likely you will have, you will have a startup. You may have some advocate to Google perhaps, or some other people. But it would be great if you started talking to these people, to the smaller. They're so busy. They're so busy. They don't even know about antitrust rules. Okay. If you talk to them, you will find surprises. If you talk to them, which I have, so I've been in particular, I gave one of my provocative talks in Stanford. That's the heart of Silicon Valley, and I was next to Halvarian of Google and people like that. After I talked, people came to me and they said, we cannot speak out often. What you said is actually right, but we cannot speak out because often the only firms that can actually buy out what we are doing is either Google or Facebook. We fear some retaliation. And this is not a good environment. If you're an entrepreneur fearing to express your views, this is not very healthy either. So this is where, this is just some anecdotes, okay? I don't have any evidence about that. But if entrepreneurs, if big tech guys there come to me and say that they fear retaliation, I would want to think about it at least. And on the geopolitical thing, this is, Eleanor Fox, she's been talking about this for ages, and this is a problem. So when we were doing big mergers in the European Commission, we had a remedy. So we knew that the beer merger was going to be a hell for people in Latin America and a hell for people in Africa. We knew that, okay? We knew that. That was the business rationale for the merger between the number 1 and number 2 beer producers in the world. But what we could obtain was a big divestiture if there were overlaps in the European market. We couldn't do much more than that. So this is a problem of size, of weak institutions, and there is a lot of work to do there, of course.
Thank you very much, Tommaso. We have a couple of questions more, but honestly, we are strict and we don't want to respect the timing. We said not more than 1 hour, 15 minutes. We already. That's
great. In London, it's almost supper time. So we're gonna.
Yeah, and actually, I have a lot of questions. So I think there's much to continue our debate on these issues, institutional issues. We're having Bill Kovacic before the end of the year. He will speak on corruption, and we have other speakers that are obviously wanting to touch related issues of those you mentioned. Thank you very, very much for your presentation. Thanks to the audience. It's great to have so many friends on board, and thanks for all the activity and the questions that everybody has posed.
Thank you for the hospitality, and thank you for the honest conversation. Bye, guys. Take care.
Cheers. Thanks.
Bye-bye.
Good fun.